Okay. All right. Good morning, good afternoon, hello, and good night. Anywhere you are, whoever you are. As you know, lately, whenever I do something in response to this official settings in Foster versus Gildred, I try to present it formally to the public first. And those are for simple reasons. I will get to that later on. But essentially, this particular video message is in response to this. And I would like to take this opportunity and let you know that I'm in receipt of your letter postmarked October 31st. It would have arrived in my mail roughly around 5 or 6 days afterwards. I would admit I only picked it up I picked it up yesterday. Not often I get to remember I need to check my mailbox. You know, we've had situations with the mail delivery that conveniently seems to be on hold somewhere else, and that's another situation. So first off, it's addressed to counsel for the defendant, and it's just to let you know that I will be disputing formally this request for dismissal. I think it's impromptu. I think there should be some formal admittance on the part of the defendant. And I also believe that as part of this video message, it should be timely enough for a genuine meet and confer, or meet to confer. Because I guarantee you, it would not be helpful, particularly for the defendant and his supporters. And that includes a number of legal entities that has been supporting this defendant over the past 7 or 8 years, as far as Gildred versus Foster and Foster versus Gildred is concerned. I'm sure from an investigative point of view, there probably is situations that needs to be investigated around legal entities backing this particular defendant way back even before Angelica Textile versus Emerald's Textiles. But that's also another situation. Not particularly any of my business. So I'm going to stick to what this is all about. And this formally is to encourage you that perhaps it's time for a genuine meet and confer. I've always encouraged this defendant that the method of mano a mano makes a lot more sense than to instruct a format where you would attempt to manipulate the legal resource simply for the fact that you have the legal entities in which would be more than happy to document any statement for and on your behalf. And because there is finance to support that, and not only finance to support it, that there is also a method in which you could call it balance your EBITDA. So it's okay to actually put forward the finance, because having been an established individual in finance, from a CPA standpoint, you can use your accredited abilities to empathize losses where legal filings or legal entities are concerned. That is also another situation. And something like that is not for me, yours truly, to formally look into. I don't profess to be an authoritative person under the umbrella of investigative authority, or folks with the ability with arrestable authority. I could only draw reference, and when I do so, I will do my best to present it to the correct party. And I promise you, and I promise myself, that when I do that, it will be factual, as it has always been. Now, as I said, this, I am disputing it, and I will be disputing it formally. And I suggest that after you've looked at this video message, that you would do some self-reconsiderations. Now, I have before me a list of documents, mostly what the defendant submitted sometime around August 11th. And there is just a lot of filings, right? I want to draw reference to a particular filing that specifically speaks of the defendant's statement, if I'm correct. In essence, the defendant's declaration. Now, let me just jump forward. There was a dramatic incident on October 31st in C-74, where the likings of a judge and the defendant were present. There were no presence of the plaintiff. Now, there was a judgment or an order from this particular judge some time ago that specifically highlighted that the plaintiff's communication has been the equivalent of coming from someone with a mental issue consistent with schizophrenia. Now, of course, if you have findings that establish that a defendant or even a plaintiff is schizophrenic from the bench, which is also has its questions, maybe you should recommend some kind of assistance and then proceed with the matter. In this case, it was made public by statement upon dismissal of that those remaining very, very concerning counts of allegations, which it seems everyone is reading the complaint differently, besides the defendant and his supporters. So those causes were dismissed. And the reason for those causes was dismissed was pretty much, well, I'll just say what it was. So here we have a statement coming from the bench that it's a ramble, it's disjointed, and it's incoherent. Now, any one of us or any part of the public would have done a very simple, you can actually just pull up any encyclopedic interpretation of those three connected terminologies, and it'll help us to understand that they're lifted from the specifics of the findings in a case of schizophrenia. There is no other reason to connect these particular disturbing syllabuses to simply dismiss a case. You could dismiss the case based on the law. You could use any one of them, or you may be able to use one or two of them or join it, but make an explanation. In this particular case, it is definitely put forward to say this complaint is indicative of someone with a case of schizophrenia. And except he actually went across and actually said that, it is left up for the interpretation of most people. My opinion, however, is there is a reverse psychological, methodological approach in something like that. Because if the intention is to induce a sense of belief, acknowledgement, or concern that it's a schizophrenic situation, then perhaps what you should do is make a recommendation accordingly, right? The downside of a reverse psychological effect in something like that, it is a hope that if in part there is a schizophrenic case at hand, there would be a reaction. And that reaction would mean perhaps an outburst, perhaps a response, perhaps the individual may show up in the court, perhaps you might receive a phone call or litany of phone calls. In other words, you receive all the elements of someone who is basically a rambler, they're disjointed, and they're incoherent, because that, along the line of being schizophrenic, allows that individual to react in rather disproportionate ways that is absurd and not welcoming to the general public, and far less for the discipline and the respect of submitting some kind of documentation before the very court that actually institute that bottom line for dismissal of the complaint. What was done, an immediate reference was drawn to the prior judge, Her Honorable Judge Carrie G. Katz, who is now retired. And subsequently, though she retired, this judge, turns out that she retired only less than, literally about 11 days after her decision. And her decision basically allowed certain context of the complaint to go forward. And this is also a public concern. Judge Carey has roughly closer to 40 years experience in serving the judicial community and at large the public. And whether it's a first or second, or whether it's a right to allow, no. If it is in fact a ramble, disjointed, and incoherent, then the law provides that even the clerk at the commencement of such litigation would have not allowed it to go forward. It's very simple to categorize terminologies that is so uniquely connected. And it's very simple to draw reference to where they're connected and who they're connected with. So therefore, again, I couldn't imagine that the court would also find that the value or the importance or the merit of the complaint even warrants the court not to provide a no-fee waiver in part, because the court can do that. It takes some looking into it. It must be a judge looking at this. So in order to say, well, look, okay, yes, this does make sense that it needs to go forward because it is of the public's interest. And if it is of the public interest, then yes, indeed, let it go forward. not tentatively in part, but fully. Now, if you were to measure the amount of motions that the defendant brought in this case, knowledgeable enough because he's been able to afford it, versus the amount of ramble and disjointed, incoherent, I would rephrase that, the amount of complaints or the amount of filings worth fee-based filings that the complainant brought in this case, that will also cause the public to be concerned. Well, who exactly or which litigant exactly needs to be labeled under those terminologies? Just a question. And this is not a question because I particularly profess to want to answer it, because I would like to, but I couldn't. I do not have that expertise. But the public is not concerned about their assumed expertise, while in some cases the public could draw reference from expert analysis, unregistered, uncertified, but there are experienced people in the public that could give very strong opinion without identifying the basis for those strong opinions. A doctor doesn't necessarily have to say that that he's a heart surgeon to recommend that maybe in his opinion that you need to get a heart transplant. Either way, the public covers all of that. And I think part of this situation has been putting the public at a backseat. And I would assure you that if the public is at a backseat, then this litigation would not have become a litigation. Yes, there is two litigants, but this particular case, it's not criminal. This particular case, it is not even a domestic situation. This case has to do with contracts. This case has to do with stipulation agreements. This case has to do with civil fraud. This case has to do with allegations of judicial corruption. And I say that largely because much of it is no more allegations. The history of this particular case shows that at least one of the judges presiding in the initiation of this management of this conflict have had to resign, not retired, resigned. And the circumstances why he had to resign was because he was not even allowing investigators to ask him basic questions about his conduct. Not even basic questions about his conduct. So he resigned and accepted a bar for life, never to seek judicial office again. By extension, you would think how many attorneys and how many litigants have benefited from this particular judge. And mind you, this is not a judge with 40 years experience. I think from what I gather, his experience is under 10 years. He did not get over the threshold so that he can really be identified as a judge who could sit on the bench and know how to divert the results of a case as if it were schizophrenic versus the deliverable of the law. So moving forward, I just wanted to bring that to your attention, because in bringing that to your attention, it helps us all to understand that what is going to be the next step? Is the next step going to continue to be some sort of a selfish litigant's motive? And would it just be driven because there is an extra layer of financing, and not because the financing is totally available? Because obviously if the financing was totally available, it might have been done already, this entire litigation. And I say so because if that was the case, then you would have had both equal sides identifying with their financial gains or their financial losses. But when there is a caveat, when a particular financial loss depends on balancing one's financial EBITDA, that's another situation, because it makes it easier to want to put finance to something, because whether you lose or not, you can call it CPRitize this situation and have it put through the various IRS loopholes, and well, it works, because IRS representatives are not always doctoring these applications, meaning going it over in with a surgical lens. So there is upsides and downsides. But the goals for this meet to confer is to help us all to understand that, be it the litigant or be it the defendant in this case, that appears to be financing quite a bit based on his legal representation, I think the larger picture here is the misinterpretation that this is a case that concerns the public. And for now, we've had one judge who's resigned. I mean, bar for life, and that's a threat to the public. And then we have another judge who is communicating. I would like to give him the benefit of the doubt. In giving him the benefit of the doubt, he is collaborating with the narrative of the defendant. And in collaborating with the narrative of the defendant, he can very well say this has been going on for 7 or 8 years, and by and large it appears that the defendant had really inflicted a lot of inducement of psychiatric expectations. And hey, if he rules like this, what does it matter? Apparently this complainant have endured quite a bit, and he's not yet throwing himself off of a building. He's not yet exercising those content of predominantly what would be a case of schizophrenia. Now, moving forward again, in doing so, the first analysis was that perhaps he needs to send a message to the defendant that even if the court were to join the defendant's narrative, it still doesn't make sense, because you're attacking the gratitude and the integrity of a plaintiff. Brings us back to the reason why the court allowed the case to go forward. Brings us back to the reason why a judge looked at the content of the case and the litigant and the history of the case and realized that perhaps this one needs not just a fee waiver, but a fee waiver in full. And then we look at the orders coming from Judge Katz just before she retired, and all of this. And it is to say to a well-worth defendant that perhaps it's time to reconsider the putting forward of the specific narrative. And mind you, I would reiterate some of those narratives. Those narratives is consistent with the plaintiff impersonated the defendant, unproven, unestablished. The person threatened the defendant, unproven, unsubstantiated. The complainant attempted to extort the defendant, unproven, unsubstantiated. The plaintiff attempted to blackmail the defendant, unproven, unsubstantiated. The plaintiff, by and large, in New York and California, 2 states, according to the defendant's unestablished police report. He has the ability just to say he made a police report, but he's unable to put that police report into evidence for the fear that that police report being into evidence can prove a criminal case against him for a false police report. But just having the terminology of a police report is enough to say that the defendant, that the plaintiff, have been involved in criminal activities, and that the defendant is, well, I can go on, right? So these are the basic things that the defendant here presented in a litany of documentation over the last 7 years. And he does so because of those three elements. One, litigation support by his associates. Two, the fact that financing is not a problem. And three, win or lose, that layer of financing can be used to balance an EBITDA of some sort. How do you say to a defendant like this to cease and desist? So it comes back to the initial goal of this defendant. And though it was on the record here, those terminologies that is consistent with that of an individual with a case of schizophrenia, this in itself is contradictory. But I would give benefit also to the seated bench that it is also sending a message to the defendant on his three-layer iconic approach to challenging this litigation over and over and over again. And I said those three iconic layers, it's because he simply can do it. He's not really a lost. If it's anyway a lost, he would probably realize it's time to. It's 7 years already. And none of his intentions or none of his accusations have been substantiated. Which leads us to understand there is only one goal of the litigation, or one goal of defending the litigation, is to set a precedent that if you put forward something and it prolongs long enough, it could drive anyone who is on the opposing side to be in a state of mental disarray. And granted, I would think, unless we have social herd immunity, he would be successful in most cases. Again, moving forward. So, I received that letter just recently, and I'm going to dispute this motion for dismissal because you're accepting that the court issued a particular judgment, which I'm going to get to that in a moment, and that particular judgment is based on the breach of the settlement agreement. But now you're requesting to dismiss the breach of settlement agreement because this judge forwarded to your favor the second count on the basis of the breach of the settlement agreement isn't ruled within your favor. That's really something that needs some questioning. And as you can look at the filing system, you would see that the motions are set for April the 10th, 2026. Gives us enough time to meet and confer. I would suggest that the defendant work on this with his legal support quicker. Now, that's one thing in dispute. As I said, it is out of context legally to assert count 2 as in favor of the defendant, while count 1 is the reason why count 2 exists. But again, that is the judicial finding so far. How that judicial finding has been influenced depends on the appellate process or the oversight committees. I am sure that the oversight committees are also looking into this matter, and many advocacy groups are also looking into this matter. Right. So, what was interesting enough is the judge did, however, avoided signing this defendant's amended proposed judgment. And if you look at the amended proposed judgment, good me, I would think that this defendant will need to be having a campaign in place so that this piece of public information is not made public. Because this is the defendant, by way of his declaration, requesting, literally, that the court exercise a decree that this defendant will act on behalf of another individual. In other words, this defendant is requesting this particular court to make it into law that it's okay for this particular defendant to impersonate another individual. That's what it says. So the judge did not sign that one. The judge did not sign the amended proposed judgment. The judge went ahead and he signed the proposed judgment. He scratched off proposed and he made it judgment. Now, the proposed judgment, so is the amended proposed judgment. Both are unenforceable. The thing about this defendant with those 3 layers of intentional approach to managing his litigation lifestyle, it shows that it doesn't matter whether it's enforceable or unenforceable. He wants to know that it's an order. And it is the reason I come up with the term legal necrophilia. To be legally necrophilic means that you don't even want to know if something is alive. I need a law that says this is or this is not. And I have the money to put to litigators who are so desperate that they will coin any theory so that they can use that finance that is freely available. And the backdrop for that is one thing, the 3rd layer of this litigant's approach. Simply because you are aware of a loophole in the IRS so that you can capitalize on any gain or loss, well, in this case, you present it as some kind of loss through the legal judicial system, so that inherently you will use it to balance your lengthy, interesting list of finances concerning your EBITDA. Again, we are at a crossroad. We are at a dead end. How do you convince someone like that to change? I have no opinion on that, but what I would suggest is not about an opinion, it's about what exists. And what exists is the prudent factor that in any civil litigation that includes this type of causes are largely dependent on the public. And at the end of the day, it's not about the litigant, defendant, or the litigant complainant, or even the presiding, in some cases, self-glorifying judges, like the one that needed to resign under judicial oversight and investigations. This particular case, the allegation did not surmount on him before this particular case. He's a young judge, right? So my point here is that this is very difficult to sequester the thought processing of an individual who is very clear on a three-layer platform for his success. What other people think doesn't have to be a concern. And even what I think, or what any other disposed litigant thought, as for example, Emerald Textile versus Angelica Textile, or is it the other way around? It doesn't really matter, because this particular case is concerned with the public. And if this is set as a precedent, it means that anyone who wants to interpret that three-layer level can literally poised on any new and upcoming budding young business entrepreneur. And they don't have to go through the normal process of meet and confer. They can just come up with an allegation and put it forward. And in this case, whether there is a response, and worse yet, if there is a response, then that litigant is subject to the whims of legal prowess and the input of financing. So this is why I am presenting to you so that you would attempt to communicate with the defendant on a meet and confer before those motions were to go in. These are just motions. And these motions, to the best of my ability, will attempt to make some changes from the bench and also from the defendant's perspective or the defendant's narrative. Getting back to the point of whether the fact that certain things are enforceable or unenforceable, it brings us of a significant reference to the T's registration, the USPTOT's registration trademark of that particular term. And that particular term, if we were to follow the records of the T's registration, it's basically a trademark that has no power. But that's from the T's perspective. And the black and white legal back and forth, wherein T's rejected this application a number of times, and the defendant continued to, the defendant just needs this to be a trademark. So T said, okay, here's a trademark with the downsides. The thing about it, this defendant is going to take that trademark, subject to correction,